Welcome back to Canadian Justice, where we're discussing the recent federal court decision that found that Justin Trudeau's invocation of the Emergencies Act was illegal and unconstitutional. Now, Sujit, you represented us in this case, and one of the big arguments that we had made at the Canadian Constitution Foundation that this threshold to invoke the act that requires a threat to the security of Canada, that did not exist as that term is defined in the Emergencies Act. What can you tell me about this part of the decision and sort of the novel argument that the government was making and how that novel argument was rebuffed here?
Well, there's a couple of points I think to consider. The first is that the Emergencies Act incorporates by reference the definition of threats to national security from the CSIS Act. And the question was, the government tried to force those two acts apart and argue that the Emergencies Act definition of a threat to national security should be read differently than the CSIS Act definition. And the court rejected that. It said the Emergencies Act could have been drafted differently, but it wasn't. And so the CSIS Act definition governed. I think the other point is that's important is a factual one. So the government essentially the core of the case turned on the Coots arms seizure, and the argument was that there was a hardened cell that had automatic weapons and body armor that was seized in a raid, and there was a worry about a chain reaction from Coots to other across the country, and that was kind of the core argument that the government made in the Rouleau Commission and also in court. And the court rejected that argument, so there was no evidence of the risk of a chain reaction. And in the lack of that type of evidence, there was no threat to national security.
So, Eva, one of the things that the court appeared to reject in this case was this argument that the government had been making that threat to the security of Canada includes economic threats. And they'd really been emphasizing this point. What can you tell me about that argument and what the court said about it?
Right. So from the beginning, when the government invoked the act, they had to provide what's called the Section 58 explanation, explaining to the public why they invoked it. And that explanation stayed relied a lot on the economic threats to Canada as a result of the border blockades. And the court and the government also relied on that in court, that these border blockades were threatening the economic security of Canada, and that a threat to national security is a threat of economic security. And Justice Mosley said you can't read that expansive definition into threats to the security of Canada. Maybe that makes sense. Maybe the act should be amended, but that's not what the act says today. So if you want to be invoking on that basis, you need to amend the act to make it broader.
So, Joanna, I think that there's been this interesting, and I think perhaps I might call it provocative argument that was made by the federal government about the amount of deference that the court needed to give to cabinet about their decision to invoke. First, maybe you can explain to our listeners what the notion of deference means, and what was so strange about this argument that the government was making that cabinet is entitled to heightened deference.
So on deference, it's basically what it sounds like. It's basically how meticulous should a judge be when reviewing a government action. And here at the hearing, the Attorney General of Canada argued that cabinet is an apex decision maker and their decision making should be seen as essentially unconstrained when responding to a fast moving situation. And all parties at the hearing, of course, agreed that deference was owed, but the argument that CCF and CCLA made was that that deference has to be within the context of the legal requirements of the act. So, in effect, Mosley agreed with CCF and CCLA and actually found that no matter how deferential I'm going to be, it was not legally available to cabinet to invoke the Emergencies Act in these circumstances, given the statutory requirements and the
Sujit,
test within the act itself.
we've got about a minute left. What do you want to say about this deference argument? Because I remember
Right.
in court when they made it, you were not a fan of this argument by the government.
No, no. I mean, look, the cabinet's not above the law. The cabinet's not a king, right? The cabinet's a statutory decision maker. And what the court sort of said is that the degree of deference that cabinet will get depends on the way the statute's drafted. And there's statutes and there's statutes. There's some grants of statutory authority to cabinet that are very broad, and those invite judicial deference. This one's not. It's what Justice Stratus in the Court of Appeals in another case called a recipe book. And there's a reason for that, which is that the history of emergencies legislation in this country is one of overreach, and the War Measures Act had very few constraints on cabinet power, and there was an enormous regret over that because it
there's
was
a
abused in 1970 in the
a
FLQ
very dark
crisis.
history. We've got to go to commercial break, but we'll be right back.